You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 98, Preissuance Submissions and How to Stop Someone Else's Patent from Being Issued. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. I recently got a question from someone about pre-issuance submissions, and I thought that I'd cover that, but I actually never did. What I did talk about were all the ways that you can get someone else's patent invalidated at the patent office once it's already been issued, and I covered those in episodes 77 through 80. But what I didn't talk about is a situation where, let's say you have a competitor, and they filed an application, and you can see that they filed it because the application has been published, which usually happens about 18 months after filing. And let's say that when they filed this application, the applicant didn't submit in their information disclosure statement a reference that you think is really important in determining whether this invention should get a patent or not, because you think that this reference makes the invention not new or obvious, and you're really concerned that if this patent issues, you might be infringing their patent, which you don't think ever should have gotten allowed in the first place. So what do? The rules don't allow you to just pick up the phone and call the examiner and say, hey, you might want to take a look at this one prior art reference and then give them a rejection based on it. In essence, that's what you actually need to do, but there's a proper procedure for you to do it the right way, or else the examiner just isn't going to listen to you. If you want to know the code where this is found, it's under 35 USC 122E, and it's called third-party pre-issuance submissions. You are the third party if you want to do this, and you can do it anonymously, and what you do is you upload the documents that you think are relevant to the patentability of the application being examined. And you should do it electronically through EFS Web, which is the same online portal that the USPTO uses when you file your applications online. You can do it on paper, and you'll need Form PTO SB 429, but I wouldn't do it by paper filing if you can avoid it. If you go to EFS Web, you'll see that you can make a submission under existing applications or patents, and you'll select the option that says third-party pre-issuance submissions under 37 CFR 1.290, and you put in the application number and the confirmation code of the application. There are some deadlines that you need to know about. This is not for when an application has already been allowed. If the application already received a notice of allowance, you cannot submit one of these third-party pre-issuance submissions. If you want to invalidate their patent after the notice of allowance, you'll have to use one of the other procedures I talked about in episodes 77 through 80. But just because it hasn't issued yet, it doesn't mean that you haven't missed other deadline requirements. And the rule is that it has to be submitted the later of either 6 months after publication or the first rejection of the application. So let's go over these two scenarios. If you see the application is published, you have at least 6 months at minimum to make your submission. So you have at least 6 months from then, as long as it hasn't received a notice of allowance. If 6 months have passed, you can still make your submission if the examiner hasn't given the first rejection. This means that if 6 months have passed and there is a first rejection, you can't do the pre-issuance submission. But if 6 months have passed and there isn't a first rejection, you can still do the submission. So let's say you're within the deadline. What do you need to do to submit? You have to submit a document where you identify the publications that you think are relevant to patentability. You have to give a description of the relevant parts and explain how it's relevant to patentability. Maybe you'll say, Claim 1 of the application has parts A, B, C, and D altogether. The reference I'm submitting is a product that has parts A, B, C, and D altogether. You're not supposed to make arguments or make conclusions, but just say what's there. And the best way to do this is with what is called a claim chart, which is basically what I just described. You make a chart of claims, which shows the limitations of the claims, and then elements that are in the references that match up with these claims. Then you need to provide the document itself, unless it's a U.S. patent or U.S. patent application. You don't need to provide that because the examiner can get it herself. The last I saw that in order to do this, you have to pay a fee of $180 for every 10 references you want to submit, or $90 if you're a small entity or micro entity. But if it's your first time submitting a reference and there are fewer than 3, that fee is actually waived. Now, there might be some advantages or disadvantages to doing a third-party submission. versus waiting for the patent to issue and then trying to invalidate it. And you should discuss these with your patent attorney if you're attempting to do third-party submissions. But for the most part, it's an easy way to make sure the examiner sees a reference that you think is really important that will make it harder for the application to turn into a patent. And that's about it for third-party submissions. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.